Yes, hello everyone. In today's video, I'm going to talk about vicarious liability and direct liability. And those are two forms of liability that need to be distinguished. If they're not distinguished, they're more likely to create problems and confusions in the mind of practitioners and students, especially when they try to plead damages under those forms of liability, and they plead basically allegations that have nothing to do with them, or they might plead direct liability allegations under the vicarious liability heading, and thus create all sorts of problems with regards to their pleading and not notifying the opposite party of where they really stand, so they can really file a responsive pleading. So what really is vicarious liability? And I want you to understand, vicarious liability is not a tort. Vicarious liability is a concept. Vicarious liability is a concept which was developed by the common law of England and Wales, and um, basically justifies the finding of liability on the part of one party because of the tort that was committed by another party. Now, this one party is the principal, right? The principal is usually an employer, a principal, somebody has given a power of attorney, and somebody who exercises control over someone else, usually through employment, when you pay someone else a salary, when you supervise him, when you have signed a contract with employment, you exercise that form of control. So the principal has his agent. That could be the employee, that could be an agent has been authorized through power of attorney or through express or authorization or implied authorization. Now, the agent commits a tort. I want you all to understand this point here, because this is what it all boils down to when a vicarious liability is concerned. We are talking about the tort of the agent. We're talking about the tort of the employee. We're talking, for example, about tort, the negligence of the employee, the agent. We're talking about the assault of the agent, the battery of the agent, the misrepresentation that was committed by the agent. Although with misrepresentation, there is a slight exception to the rule, but that's with fraudulent misrepresentation, and we're going to come to that a little bit later on during the course of this video. Now, so when you plead your pleadings under vicarious liability, all you have to do is you are going to talk about the negligence of a certain party, of that agent, the negligence, how he had a duty of care, how he breached that duty, and how negligence resulted, how damages resulted through that breach of duty. You're not going to talk about the employer. What you're gonna have to do, the only thing you're gonna have to do is basically mention that the employer was employing him, and that he was holding it out. He employed him in a certain position. So this is vicarious liability. If, for example, the employer failed to supervise adequately, sufficiently, and if he supervised negligently, or he didn't even supervise at all when he had to supervise him, or he didn't have a same system of work, or he failed to maintain a car which the agent was driving, and he crashed it he collided his car with a third party during the course of his employment while he was going to a destination during the course of his employment. Then there's another form of liability that is a separate head of liability and can concurrently run with the vicarious liability. And this is the direct liability of the employer. What I want you to understand is, even though with both liabilities, in both liabilities, there may be an agent and there may be an employer, a principal involved. In the vicarious liability, we focus on the agent. We focus on the tort of the agent. We're going to plead how the agent committed the assault, under what circumstances, under those certain allegations. The employer actually could have done basically nothing. Now, if though there's direct liability, we can also plead that the employer had direct liability and he failed to supervise him. He did negligent hiring. He hired negligently, let's say, a security guard who who had anger management issues, so he assaulted a third party in the course of his employment. Now, he could have the employer could have authorized that act. That would have made him vicariously liable. And when you plead direct liability of the employer for negligently hiring the security guard, then you're going to have to plead all those circumstances that will show the negligent hiring. How he was negligent hiring. How did he, the omissions that he made. How he had knowledge that certain, or he ought to have knowledge about the certain security guard, let's say. Now, when there is fraud involved, the fraud in, let's say, deceit, more correctly put, if there is a deceit in the form of a misrepresentation, that would have made it a fraudulent misrepresentation, and the agent makes a false statement but has not the necessary fraudulent, deceitful, dishonest mind, then, and the principal has the dishonest mind and he knows that the statement is made, then the principal is directly liable. There's no vicarious liability as such. If you plead vicarious liability and you plead at the same time that it was the principal who had the fraudulent state of mind, the principal who knew that the statement was being made, and the principal who had the dishonest state of mind, and you plead a vicarious liability, you're more likely to confuse the opposite party. He won't know what defense to put in, because we're talking about two individuals. The one is vicarious liability, which he must focus and he must put a defense against the Tortures Act of an agent, and the other is direct liability, of course, when you claim that the principal had the fraudulent state of mind, and he'll have to counter that, not through the agent, but he have to counter he put a defense against the allegation that the principal had a fraudulent state of mind. And you're more likely to confuse that. If he won't know how to focus and under what circumstances to focus, like did he know, didn't he know, how did he have that kind of state of mind, which person did have that kind of state of mind. Yes, you're claiming that the principal had the same mind, but on the other hand, you're claiming he was vicariously liable. Will he have to also put a defense for the employee? Because vicarious liability means that the agent committed the misrepresentation, he issued the false statement basically, and that he had a fraudulent state of mind. So he will have to put a defense for the agent too. If both, because both can run concurrently at the same time, you need to plead both. You need to plead vicarious liability and or direct liability, and state that the agent and the principal both had the fraudulent state of mind under the circumstances. Like the principal had the fraudulent state of mind, like in his own right, and the agent was acting also fraudulently because this and this and this and this, and he knew the truth, or he was actually reckless with regards to the truth, and he had an intention to, for the third party to rely upon. If you can't, for example, if he didn't have the intention, if he didn't have the fraudulent state of mind, then it will be, the principal who had the fraudulent state of mind. So you you can plead both those states of mind at the same time, but just mention it, just say the that there was misrepresentation. You can mention under two separate claims, and it will be better, or that they both should have known. Usually, usually um, the usually the circumstances under which you can claim that, let's say, the principal ought to have known. If the principal ought to have known, because he's a businessman, he owed to have known better. Um, Sometimes they could have been different, because it depends who owed to have known better, who could have known actually better, who owed to have known better, not could have known, who owed to have known better, because the agent might be a specialist in something that actually the principal and the people that have put him in that place, didn't really know of certain knowledge. So, or even the reverse, it's quite possible that the principal knew certain stuff, and the circumstances under which he owed to have known, he knew, are different from those of the agent who didn't, who was reckless with regard to the truth, or who knew the truth under certain circumstances. So, yeah, this is what I wanted to highlight in the course of this video. I have made a previous video where I break down the liability in for fraudulent misrepresentation of a principal when the misrepresentation has been made by his agent. But I will make also a separate video where I will be breaking down those principles more in order to understand the dynamics that come into play, because it's something really important, and something that with a lot of corporate fraud occurring is a it's basically a common occurrence, common phenomenon within the legal world. Thanks very much for watching. This is Dimitris Koulafetis. Please subscribe to my channel for more videos like that. And this is not legal advice under any circumstances. Thank you very much. See ya.